My Lords, I wanted to now turn to dealing with the appellant's case on the question of the construction of the undertakings, and the question of context, which we've already I've already made a few submissions on already, but I wanted to go straight to the undertaking given by Mr. Deripaska. Now, your Lordship's already had cause to look at that with my learned friend, but I wanted to start with what actually Mr. Deripaska promised this court to do and not to do. Your Lordships may recall this is Core Bundle tab 11, page 103, and the critical paragraph is paragraph 4. Once the undertakings have been provided by Mr. Wisniewski on behalf of B Finance, I understand that Fidelitas is unable to take any step to frustrate compliance with or enforcement of the undertakings. Pausing there, Fidelitas, your Lordships may recall, is the owner of B Finance in broad terms, and Mr. Deripaska is a beneficiary of Fidelitas. Nevertheless, and for the avoidance of doubt, I hereby further undertake to the court in connection with the above proceedings as follows. A, I shall not take any step or procure the taking of any step, whether directly or indirectly, in my capacity as ultimate beneficial owner or in any other capacity which has the effect of preventing, impeding or obstructing the fulfilment of the undertakings set out in the B Finance letter, as they may fall due for performance. Pausing there, my Lords, count 1 and count 2 are founded on alleged breach of 4A, and then B, I shall take all steps as are necessary to ensure that the underlying assets, being the 45.5 million unencumbered shares legally owned by B Finance in N Plus Group, remain available for direct enforcement. And that gives rise, little b, that is the positive undertaking said to, which is found count 3, as we have seen. And before I go any further, my Lords, I want to just note that that undertaking does not refer in any shape or form to the RPC undertaking. It refers solely to the B Finance letter, which contains undertakings, undoubtedly. And secondly, that it does not carry with it the description of the shares that my learned friend places so much reliance upon, as contained in the B Finance undertaking. We shall look at the B Finance undertaking in a minute or so. But pausing at the Deripaska undertaking, on its face, what Mr. Deripaska undertakes to do or not to do is, 1, he promises that the underlying assets will remain available for direct enforcement, and the underlying assets are defined in the parenthesized words at 4B, and of course that carries with it the question of what available for direct enforcement means, as to which Judge Pelling offered an answer, and a correct answer. I shall come back to that in due course, because my learned friend made certain submissions on the meaning of that phrase. 2, he promises at little a, in the terms that we have seen, not to take any steps, putting it briefly, which had the effect of preventing, impeding or obstructing the fulfilment of the undertaking set out in B Finance, not the undertaking set out in the RPC letter. We should look briefly at the B Finance letter, because my learned friend places heavy reliance on this is page 100, I should say, places heavy reliance on paragraph 3 and the description of the shares, as your Lordships may recall from yesterday's submissions. That is para 3, I should say, of the B Finance letter at page 100. And your Lordships will have noted that the description in the Deripaska undertaking differs from the description in the B Finance undertaking. Now, with those preliminary comments, I wish to make a number of further observations as to what the undertakings do not say on any fair and reasonable reading of them in my submission. And when I refer to the undertakings, I'm referring to the B Finance and Deripaska undertakings being the relevant ones from the point of view of Deripaska, but the submissions relate just as much to the RPC undertaking. They say nothing about preserving the domicile of the shares or the domicile of the company itself in a particular location. They do not say, as they could have said, in the sense of a draftsperson could have incorporated language and clear language to say, I, Mr. Deripaska, promise to ensure, or I, Mr. Wisniewski of B Finance, promise to ensure that the company will not relocate from Jersey to some other jurisdiction, whether any other jurisdiction in the world or, in my learned friend's evocative language, not to Russia. They do not say that. And given Mr. Chanukin's knowledge of the fact of a possible redomiciliation in June 2018, prior to the signing of these undertakings, it is a question which is worth noting, a point which is worth noting, that he did not insist upon on that language at that time. Now, what we can infer quite heavily from Mr. Deripaska's unchallenged evidence is that if Mr. Chanukin were to have said, look, your proposed undertakings are all very well and good, but it's really important to me that the shares that are the subject of the undertaking remain in a Jersey registered company and no other company, or no other jurisdiction, you must promise to ensure that the company remains Jersey registered, then one can safely assume that Mr. Deripaska would have responded via his lawyer, saying, well, that creates a real problem, because if I was to promise that, then the whole apparatus of the Barker plan, dependent as it was on the continuance, will collapse, and potentially many thousands of Russian employees will fall into unemployment.
Well, putting the point the other way around, and these two undertakings are dated the 28th of June 2018, and the article, the newspaper article, which Mr. Chanukin says he read when it came out, was dated the 24th of June.
It was, yeah.
So the issue of the continuance, one would expect to have been at the forefront of his mind.
Well, your lordship is right, and that gives rise to this further submission that Mr. Pelling KC, King's Counsel, who was representing Mr. Deripaska at the trial before Mr. Andrew Baker when the claimant's witness, I should say, was cross-examined. I have no doubt that Mr. Pelling would have had some extremely searching questions to pose to Mr. Chanukin about that question amongst many others, including his knowledge at every stage of the continuance process, which, as I've said, was placed on the public stage. But Mr. Chanukin made a decision not to put in his own affidavit, but to hide behind Ms. Barad's evidence. So he couldn't be asked questions which would no doubt have been extremely interesting for the purposes of disposing of this application. My lord, so the first point I make about the undertakings, or the next point I make about the undertakings, is that they do not contain within them any language saying I promise or we promise not to change the domicile of the shares or not to change the certificated status of the shares.
You're making a point about the construction of the undertakings.
Yes.
For that purpose, should it be taken as something that was the common understanding of both parties that Mr. Chanukin had read the press articles?
Well, I can't.
We now know that he had, but was that something which should be taken to be part of the contractual background?
Well, can I just say the contractual word? It shouldn't be. I wouldn't associate myself with the word contractual.
You're
The
right.
background.
Yes, fair
With
enough.
I don't want to be
No,
negative.
fair enough. I withdraw.
No, it's not at all. Your Lordship is always right, it's fair to say. Mr. Deripaska did not know that Mr. Chanukin was poring over that article on the 24th of June. What the parties knew undoubtedly in late June was that the fact of the redomiciliation was a public fact, which it's not a private fact to Deripaska or to N+. It was a fact in the world that it was being contemplated. The fact that Chanukin actually knew it is, I say, further relevant, carries its own heft, but it was an objective fact in the world, knowable and known to both parties. That's my answer to your lordship's question. So that's what the undertakings do not say. Can I now, when considering the meaning of the undertakings, just turn up my learned friend's skeleton argument, because he has a lot of things to say about this. And this is tab 3 of the core bundle. And if we pick up that at paragraph 17, page 7, internal pagination. I just want to squash, if I can, one particular point. Now, at paragraph 17, what Mr. Chanukin says via his counsel is pausing. This is in the context of a survey of what was happening throughout 2018, or a short survey, which I'm going to come back to in greater detail. Pausing there, it's important to emphasise that if in 2018 Mr. Deripaska had offered to give undertakings in relation to shares in a Russian company, any such offer would have been dismissed out of hand, both by the claimants and by the court. Well, I'm not aware there's any evidence to that effect. I'm not aware that Mr. Chanukin certainly hasn't told us what he believes, because he's hidden behind Ms. Barrard. And what the court would or would not have done is frankly not something that my learned friends should be even speculating about, let alone making categorical statements about what the court would or would not have done. And I'm going to come back to that point.
But it all depended on whether Mr. Chanukin, assuming that had been the case, there had been shares in a Russian company in relation to which the undertaking was being given. If Mr. Chanukin was prepared to accept that for whatever reason, and as you rightly say, there's no evidence that he was or wasn't, then the chances are the court would have accepted that.
Well, I agree with that, with the greatest respect. But the point goes a little further, and I'm going to preempt a submission I was going to make in 10 minutes, but I'll make it now, which is the whole structure of my learned friend's skeleton argument, an argument at this stage of his written argument, is effectively saying, look what happened. Mr. Chanukin turns up at court before Mr. Justice Robin Knowles on the 11th of May on a short notice application in which Mr. Deripaska was given, I think, 2 days notice of that in circumstances where he was sanctioned, and therefore he had actually no effective legal representation at all. So it was effectively a without notice application. Mr. Justice Robin Knowles therefore only heard from the Chanukin side. Counsel did attend for Deripaska, but only to ask for an adjournment. He had no further instructions, and that adjournment application was refused. So it's effectively a without notice application in which Mr. Justice Robin Knowles was willing to grant an injunction in the terms that your lordship has seen, because my learned friend showed it to you yesterday. And my learned friends seek to obtain some sort of forensic benefit from what Mr. Justice Robin Knowles, on a without notice application, ordered. It's elementary that there is no forensic advantage or legal advantage of any sort obtained by what a judge orders on a without notice application. So when a party comes back to seek to set aside a without notice order, the claimant doesn't point to, well, look, a judge has already said that I've got a good case. and therefore you're sort of 1-0 or 2-0 down, the court starts afresh, because nothing that is done without notice carries with it any persuasive burden or advantage, rather. So there's a whole host of submissions made by my learned friends saying, well, look, this is what Mr. Justice Robin Knowles agreed to on an ex parte application. Matters not one iota. What really does matter, we would say, is that what then happens is that Mr. Deripaska, and I'm slightly taking this out of kilter, but only to answer my lord's question and point. What then happens is that Mr. Deripaska, once his lawyers have got a specific licence allowing them to act substantively in the litigation, is issues an application on the 5th of June 2018 to set aside the freezing order in its entirety, saying this should never have happened, the judge was misled, Mr. Justice Knowles was misled, the evidence for risk of dissipation is completely fallacious, the evidence of non-enforceability in Russia is completely bogus, and makes a full-fronted attack on the, not a criticism of Mr. Justice Robin Knowles, of course, but an attack on the order. And that's the circumstance in which the undertakings are finally accepted. And what actually happens, and it's quite interesting, what actually happens is that Mr. Fenwick is acting for Mr. Deripaska at the time. I think Mr. Crowe is acting for, my learned friend is acting for the Chanukin parties. They attend before Mr. Justice Robin Knowles. Mr. Fenwick's skeleton argument is basically saying this freezing order should have been completely set aside because it was wrongly obtained on many levels. But we are willing to offer certain undertakings. Mr. Crowe says the undertakings are all entirely inapposite and inadequate for all manner of reasons. And then Mr. Justice Robin Knowles says, well, Mr. Crowe, you've just got to be careful here because if you don't accept the undertakings, then I will rule on the question of whether this freezing order should be set aside in its entirety. I'm not going to tell you what my answer is, I have to hear the evidence, but I will rule on that. And Mr. Chanukin obviously didn't have the stomach for that fight, because there's then a short adjournment and Mr. Crowe comes back into court and says, my client is willing to accept the undertakings. Those are the circumstances of the undertakings being accepted by the court and being accepted by Mr. Chanukin. A heavily contested, all singing, all dancing application to set aside a freezing order with eminent counsel on both sides about to engage in a hammer and tongs debate on the question. That is a minor digression, but it may answer my lord's point about whether or not the court would have dismissed it out of hand. The court was plainly willing, without having formed any final view, to entertain an application to set aside the freezing order in its entirety. And the court...
It's a bit odd, isn't it, that the application to set aside the freezing order didn't say, you ought to know, we've got to re-domicile all these shares in Russia because otherwise the company's going to collapse.
My lord, Mr. Deripaska has, in his evidence, accepted that it would have been far better, without acceptance of any...
I mean, it might have given rise to arguments about whether that was in the ordinary course of business, which of course you're allowed to continue.
Yeah. Well, Lord, I think it's accepted and has been for 4 years now on this side of the court that Mr. Deripaska, putting aside questions of breach and everything else, but just taking a realistic view of keeping this court abreast of matters, he accepts that, and he has apologised for that, and he repeated that apology orally at the trial before Judge Pelling in March of last year. My lord, that's paragraph 17, which I just wanted to alight upon. Can we go to paragraph 22 of the same document now, which is internal page 9. What my learned friends there say is, as to their case on meaning, the intended effect and operation of the undertakings, I'm so sorry, I'm looking at the wrong, paragraph 22, the package of undertakings was thus formulated to avoid any need for the claimants to rely on the Russian courts or Russian assets for the purposes of enforcement. In particular, if Mr. Deripaska or B Finance defaulted on their obligations, the claimants were assured that an order made by the High Court for the sale of the shares would ultimately be satisfied on the basis that the registration of such shares would be effected in Jersey. Now, it should be, in my submission, uncontroversial that the undertakings that were actually signed and offered and accepted by the court go nowhere near, even with the closest and most forensic microscope, that proposition. And I also contest the word thus, because it suggests that Mr. Deripaska was conceding some sort of point, and conceding the legitimacy and propriety of certain articulated concerns on the part of Mr. Chanukian, and therefore offering undertakings designed to meet certain concerns. He emphatically was not doing so. My lords, before we go any further, I wish to now spend what may be only 4 or 5 minutes talking, or making submissions rather, about the proper approach to the interpretation of orders and undertakings. Now, a lot of this will be hornbook law to your lordship, so I'll keep this as short as possible. And indeed, one of the leading authorities is that of Lord Justice Flair. But I'm prompted to do so by my Lord Justice Lewison's intervention just before the short adjournment, when my Lord made a particularly pertinent, if I may say so, point by reference to Mr. Justice Mumby's decision in Harris and Harris. My Lord, over the short adjournment, I looked to see that whether I was right, and I was, that Lord Justice Nugee referred to it in Keir. Can I just very briefly just show you the reference in Keir, which is Authorities Bundle, tab 11, page 330. It's paragraph 45, little 3, at the top of the page at 330 of Lord Justice Nugee's judgment, where he referred to Harris and Harris, where Mr. Justice Mumby, as he then was, made the point that no order will be enforced by committal unless it's expressed in clear, certain and unambiguous language. So far as that is possible, the person affected should know with complete precision what it is that he is required to do or abstain from doing. He continued, and this was the correct memory of Mr. Lord Justice Lewison, a related principle is that an order should not require the person to whom it is addressed to cross-refer to other material in order to ascertain his precise obligation. And I of course, advance that as a wholly correct statement of the law, and a relevant statement considering my learned friend's submissions that you've heard.
But do you go as far as to say that Judge Pelling was wrong to consider the undertakings as a package?
They were a package. I've no doubt. I don't dispute that. The three of them were put forward, and I quite accept that in one sense, in a very clear sense, the Deripaska undertaking was expressly cross-referred to the B Finance undertaking, and
indeed it attached to B.
And it absolutely did, yes. So I accept that they were presented as a package, but the caveat I draw, which I'm not sure this involves any quibbling or quarrelling with Judge Pelling, the caveat I advance is that the Deripaska undertaking did not in terms refer to or cross-refer to or anything else to the RPC undertaking.
So what Mr. Justice Mumby said is something you rely on, first of all, to say that the RPC undertaking doesn't affect the interpretation of Mr. Deripaska's undertaking, and secondly, that the background correspondence likewise can't affect the interpretation of Mr. Deripaska's undertaking.
I do say that, and it's fair to say that from the point of view of the claimants, they do not found, at least in their application notice, the matter may be rather different now, they do not seek to argue or suggest that the Deripaska undertaking was breached by reference to anything said in the RPC undertaking. Paragraph 22 says nothing at all. The crucial paragraph 22 of the application notice says nothing at all about the RPC undertaking. Although it refers to the share certificates, it doesn't carry that through to any actual breach at paragraph 22D. My lords, the other principle, apart from that to be found in Pan Petroleum and Harris, that is of relevance here, which is will again be of no surprise to your lordships, which was stated in Navigator by Lady Justice Carr back in 2021, paragraph 82, Roman 4, I don't need to show you it, which is that undertakings or orders are to be construed strictly for obvious salutary reasons, given the penal consequences or potentially penal consequences of breach.
Yeah.
Moving on, those are my submissions on the proper approach to considering the undertakings, and I've effectively set out at greater length submissions at paragraphs 55 to 58 of my skeleton argument. Moving on to consider in greater detail what it is that the claimants say about these undertakings. Before I come to consider the gravamen of their current case, I say current because it finds no articulation in the application notice, and in that sense my submissions are all without prejudice to the fact that none of these matters arise at all. The first preliminary point that I wish to just remind this court of, if it needs reminding, that is that the undertakings created and are not suggested to have created any form of security interest in the shares in favour of the Chanukian parties. The shares were not pledged, they were not charged, no lien was created over them, and that is not, of course, alleged in the application notice. All that the undertakings did was constitute personal promises by B Finance and Mr. Deripaska, and in certain circumstances RPC, to do or refrain from doing certain things in certain contingencies. Most importantly, if Mr. Deripaska failed to pay the awards within 42 days after the dismissal assumed of his Section 67 and 68 application. That is an important consideration on a number of levels. Having put that to one side, what ultimately is it said by now, not in the Berard affidavit, not in the application notice, but now before this court, what is it said that the undertakings prevented Mr. Deripaska doing or required him to do? What it is ultimately now said, as far as I understood my learned friend's submissions, is that any step taken by Mr. Deripaska or not prevented by Mr. Deripaska in circumstances where he could have prevented it, which results in, one, the shares ceasing to be Jersey registered, or two, those shares ceasing to be certificated, amounts to a breach of the undertaking, and therefore it must follow that the undertakings properly construed, as my learned friend would have it, contained within them negative or positive obligations, as the case may be, to preserve the Jersey registered status of the company and to preserve the certificated status of the shares. To carry home his case, if he's allowed to make it at all, which he is not, he would have to establish, when I say that because the application notice doesn't go anywhere near this, so these are all without prejudice to that submissions, he would have to be able to establish that the undertaking, read within its four walls, without reference to anything else, and on a strict and close reading, had those two positive or negative obligations, as the case may be. Now, as far as I can see, the beginning, middle, and end of that submission, putting aside this contextual stuff, which I'm going to come on to, is that the shares in the B Finance undertaking, but not the Deripaska undertaking, had a descriptive element to them, which essentially described the shares in B Finance, not in Deripaska undertaking, as being shares in a Jersey company and being certificated. Now, it baffles me, certainly, how one can elevate a description of certain shares into a positive obligation enforceable by penal incarceration to procure that something remains the same, or prevents it not remaining the same as however you want to cast the undertaking. That in my submission, is not only not argued in the application notice and the evidence, but even if it were available as a point to my learned friend, a wholly unarguable point. No reasonable reader of those undertakings, reading it by reference to the learning of Lord Justice Flo in Pan, Mr. Justice Mumby in Harris, and many other judges over the years, could conceivably look at those undertakings and think, those undertakings prevent me from redomiciling this company, or require me to prevent the redomiciliation of this company to any other jurisdiction in the world. Because apparently that's the high point of this submission, and one might just test that proposition very briefly before we come on to the contextual material relied upon by my learned friend. It therefore necessarily follows, so I understand, that if your lordships may recall that N+ was proposing to redomicile to Cyprus, and that was happening in 2017 before the sanction issue came about, and that changed for the reasons we've all seen. Now, apparently on my learned friend's case, as it now is articulated, had N+ redomiciled from Jersey to Cyprus, then that would have been a breach which would give rise to my client's incarceration. To even articulate the point, surely, in my respectful submission, reveals it to be an utterly fallacious point. Let's do another postulate. Let's say that the Jersey shares were, the Jersey company was redomiciled post the undertakings being given to Guernsey, or Alderney, just for argument's sake. Would it be said that that was a contempt of court? Of course it wouldn't be said it was a contempt of court. My learned friend in reality has to say, and I think basically did say yesterday in argument, that what the undertaking actually prevented was redomiciliation to Russia, not Russia, as my learned friend said. That's the point, as he said. Well, that, of course, once you've arrived at that position, you're in even further intellectual muddle. So effectively, on that analysis, the undertakings prevent on their face, so it must be said, prevent the Jersey company from being redomiciled to Russia, not any other jurisdiction, but Russia. Well, it would be, I've looked at those undertakings many times, I know your lordships have as well. It is literally impossible to articulate that promise from those undertakings. And that is why my learned friend is driven to rely upon the supposed contextual material. And he is driven to suggest that somehow there was a joint understanding of some sort. That's how he puts it in his skeleton argument, I think. I think he may have modified his position in oral submissions. Some sort of joint understanding where Mr. Deripaska implicitly or explicitly says, Mr. Chanukin, I understand your concerns and I wish to meet those concerns because they are, to use my learned friend's submission yesterday, objectively justifiable concerns. That is what he has to say. Now, with respect, that is just a heresy. It's a heresy which needs to be paid to with respect by this court. The notion that you have to, or entitled to rather, troll through contentious correspondence between solicitors leading up to the undertakings to work out what they mean, I've already made that submission before the short adjournment, is it's heretical and in any event a recipe for disaster for these courts and for the litigants who are hauled before them on committal applications. Let me now look at what is the material relied upon. I'm going to take this relatively quickly, if I may. The material is relied upon in my learned friend's skeleton argument over a good deal of pages. It starts at paragraph 14, tab 3, internal page 6, please. The first point, which my learned friend didn't articulate orally, is that in some proceedings against Ms. Danilina, a security for costs order was made on the basis of a real risk that the Russian courts would fail to give effect to the orders of the English court. That's an order made not against my client in any shape or form, so far as I understand. And then there's a reference to a case called Tatneft and Bogolyubov, which my client was not in any way associated with or so I'm not quite sure how that should be relied upon to gloss my client's undertakings given to this court in June 2019. Then that's paragraph 14. We go to paragraph 15 briefly. This is you've already read this, my lords. This is the affidavit of Ms. Berard served in support of the application for the WFO. Now, those concerns are articulated by the claimants. So what? So what? That the claimant put in evidence in support of a freezing order which was absolutely and fundamentally opposed by Mr. Deripaska at every step of the way. Totally irrelevant. The fact that my learned friend thinks that it's appropriate to rely on evidence given by a solicitor in contentious litigation to gloss the interpretation of an undertaking given 6 weeks later is, I would suggest, a misapprehension, with the greatest respect, of the law. Now, paragraph 16. The above invitation was accepted by the court. So the point that is sought to be made there, apparently, is that, well, the court agreed with Ms. Berard and agreed with the Chanukin parties. Because look at the order that was made. Well, I've already explained, my lord, that that order was made ex parte without any evidence or any submissions by my client, who I think had 2 days' notice of this application. So one obtains literally no guidance or benefit at all, without any disrespect, of course, to Mr. Justice Robin Knowles, from what the learned judge ordered on the 11th of May. And then just note this, that word accordingly at the return date of the WFO application, the parties proceeded on the basis, I mean, my lord, the sheer fallacy of this case is just demonstrated by that sentence, with the greatest respect. Accordingly, at the return date of the WFO application, the parties, that includes apparently my client and the court, proceeded on the basis that any freezing order and or security would only be effective insofar as it related to assets outside Russia. That sentence should never have found inclusion, with the greatest respect, in a skeleton argument. There's no accordingly about it at all. Because what actually happened, omitted by my learned friends, is that on the 5th of June 2018, my client, as I've explained to my lords 10 minutes ago, launched an all-out attack on the propriety of the order that had been obtained by the Chanukin parties. Now, I want to carry on reading this material, because it may assist your lordships in understanding the strength or otherwise of my learned friend's case. The notional value of Mr. Deripaska's assets, as opposed to the availability of enforcement against those assets, was thus of secondary importance, as if somehow the parties had reached a kind of common agreement on it, or this was now an established, indisputable fact between the parties. Untrue. Simply untrue. Paragraph 17 we've looked at already. I don't need to trouble your lordships with that. Paragraph 18. Against that background, well, there's no background of any meaningful nature. At the return date of the WFO application in June 2018, Mr. Deripaska proposed a package of 3 sets of undertakings. So my learned friends have decided to omit the fact that between the ex parte application and the June 2018 return date, my clients had launched the all-out attack on the propriety of the order. And it's as if, the way it's put is as if my clients thought, well, you've got your order, there's nothing we can do about it, we understand your problems, we completely see the propriety and of the difficulty about enforcement in Russia. Here are a bunch of undertakings to meet that problem. Every aspect of that is just false, with the greatest respect. The precise terms of proposed undertakings are the subject of detailed negotiations following the return date. That may be right, but that only proves the point which my Lord Justice Lewison made, is that on any view, the idea that negotiations should be admissible for the purposes of construing an undertaking is as heretical as it is in the contractual context. Now, just pausing there, my learned friend omits the fact, which I've just explained to the court, that in fact Mr. Chanukin was put to his election, so to speak, and funked it, and took the view that he better grab the undertakings because he was at risk of having his freezing order entirely lost to him. Now that's paragraph 18. Let's go to paragraph 19. It is of crucial importance that the subject matter of all the proposed undertakings consisted of 45.5 million certificated shares in the Jersey company. That's a mere assertion. Why is it of crucial importance? My learned friend doesn't elaborate. It was a fact, because that was the fact of that was the shares that were being offered by way of undertaking. Thus, the B Finance undertaking defined the shares as follows. That word thus again, as if somehow that thus, everything, that definition brings in everything that's come before it. The B Finance undertaking defined the shares. My only friend's case in reality is that definition is to be elevated into certain unarticulated positive and negative obligations enforceable by a committal application.
Well, the undertaking had to identify the subject matter of the undertaking.
Otherwise, it would be just an absurd document.
And we know that B Finance owned 245 million, of which it was prepared to offer 45.5 million.
Yes.
So you need to differentiate between the 245 million and the 45.5 million. And you do that by saying, well, the 45.5 million are certificated.
Otherwise, you don't know what you're talking about. All right, your lordship's absolutely right, of course.
So having identified the shares, one might say, well, if those shares disappear and are replaced by different shares, then there has been a breach of the undertaking because the subject matter no longer exists. But Judge Pelling, I think, found at paragraph 52 and 53 that the shares are the same shares.
Yes, not challenged.
Both before and after the redomiciliation.
And that's not challenged.
So, having identified the subject matter of the undertaking, that subject matter continues to exist.
Quite. That's exactly. My lord has it. The further, perhaps more adjectival point, but nonetheless an important point.
That's why it all comes back to cancellation ultimately.
Yes, that's what
Either Mr. Grove's right, the shares were cancelled in the way in which he says they were, in which case at least it seems to me there would have been a breach of the undertaking, or he's wrong, as the judge found. And if he's wrong, then as my lord just put you, Judge Pelling found these are the same shares. They weren't cancelled in.
Well, I think what my learned friend
at all.
Can I just pick that up for a second? That point with respect. I think what my learned friend says is that I accept they weren't cancelled in any real world sense. Hence his attempt to kind of de-dignify the word cancellation by using words like technical, as if somehow, let's not get hung up about cancellation. My learned friend essentially recast his case entirely and say, by the word cancellation, I mean, in fact, not cancellation at all. I mean changing certain of their characteristics, which is, we'd say nowhere. A has got nothing to do with the application notice I came to meet, and B has got nothing to do with the undertakings. I mean, I objected on every level. I should say that's that submission.
Yeah.
But I would want to add just this further. Of course, Clifford Chance at every step of the way, when these undertakings are being offered, was saying they're hopeless and they're just not good enough, and that's why there was a hearing on the 18th, when, as I put it without any disrespect whatsoever, Mr. Chanukin funked the application and decided to grab what he could, putting it bluntly, but not pejoratively. My lord, just for your lordship's note of the Clifford Chance letters that objected to the undertakings, it's supplemental bundle tab 6, 7, and 11. I don't want to take up time going to those. And then this, para 20, the definition of the shares appears after the description held in certificated form, which puts beyond doubt that their certificated status was fundamental. I just don't know what that means. I just don't know what that means. It was descriptive, undoubtedly, for the reasons my lord has said. It would have been quite helpful to have a descriptive status, because otherwise one doesn't know what one's talking about. My lords, there's then various things said about the purposes, which I don't propose to talk about or make submissions on, because I think I've already addressed them. But in the context of context, we then get to paragraph 22 over the page at 9. Now, I've already dealt with paragraph 22 in the sense I've made submissions on it. I'd just like to briefly canter through para 23, which is the letters. These are certain Deripaska letters, none of which are referred to by Ms. Barrard in her affidavit as being of any evidential value whatsoever. This is a point occurring to Mr. Chanukin apparently years after his application notice was issued. None of them are referred to in any meaningful way or at all in the application notice itself. This is the rearguard action at work. First of all, it said, well, in a Brian Cave letter of the 23rd of May, the effect of this arrangement will be that assets will be made available in London. Well, I mean, not quite clear what real benefit one can obtain from that, but in any event, it's just obviously factually wrong. Nothing of value was made available in London. Some share certificates, which in and of themselves carried no value whatsoever, were placed eventually placed in RPC's safekeeping. But nothing was actually placed of value in the sense of assets in London. It's just a misuse of language by Brian Cave. That's the first point. The second, we then get on to the next letter of the 1st of June. Deripaska is the ultimate beneficial owner of B Finance, and then just notice the underlining. N Plus Group PLC, a Jersey company. And my learned friends will underline it as if, the key to this case is unlocked. I mean, it's quite obvious that when you're going to refer to a company, you might refer to its place of registration in order to identify what it is. Of these, Deripaska has offered undertakings in respect to a block of 35.5 million shares, which are currently held in certificated form in London. That's somehow underlined as if there's some great significance to it, and so on. And one can find really no benefit whatsoever, even assuming my learned friend's approach to interpretation is correct, which it is not. And then a reference to a witness statement of Mr. Ray. Now, I want to just spend a tiny bit of time dealing with Mr. Ray's witness statement, because it's actually quite useful, contains some quite interesting material for the purposes of analysing the significance and strength of my learned friend's case. We're back to the supplemental bundle. The Ray witness statement is at tab 9. This was in the context of seeking to set aside the order. Page 45. Paragraph 7, no justification for the exercise of the discretion to grant a worldwide freezing order. And then paragraph 8, for pragmatic reasons, essentially he says, we've offered certain undertakings. So what's happening is that Deripaska says this freezing order should never be granted, and I'm proposing to set it aside. But reluctantly, for pragmatic reasons, I'm willing to offer some undertakings. That's the beginning, middle, and end of it. And then one of the points that is strongly made by Mr. Chanukin, apparently, is that, well, one of our real concerns was the difficulty of enforcement in Russia, hence the not in Russia point that my learned friend made so many times yesterday. Not in Russia. And the reason for that was, oh, well, it'd be very difficult for Mr. Chanukin to enforce any award or any undertaking or any order he got, pecuniary order, in Russia because of the court system or whatever, and Mr. Deripaska's supposed influence or whatever. Now, of course, your lordships are not here to decide that question. Your lordships are here to decide whether that was some sort of common ground point. And the answer is it wasn't a common ground point in any shape or form. And one sees that from paragraph 181 of Mr. Ray's witness statement at page 51, where he refers to a report produced by Mr., which your lordships haven't been troubled with, Clifford Chance, from a gentleman called Kulkov, in which Kulkov had said, oh, it's very difficult to enforce in Russia. And to which the response was, that's just not right. And we've got a report from a Russian law firm, not your lordship has not been troubled with it, saying the Russian, remember, we're dealing here in 2018, my lords, it's easy to bring 2024 understand this, but we're not in 2024, we're in 2018, where essentially what is being said is that there is no difficulty of enforcing awards in Russia. It's just wrong. And there's a reference to Mr. Justice Christopher Clark, and there's a reference to the decision in Erst, where apparently that point was made. I have to confess I've not gone back to Erst. I think it was a decision of my lord. But the point is made there as well. So what is said by Ray, there appears to be no basis at all for Berard's statement that more recently certain steps have been taken which are indicative of the Russian courts retreating from internationally recognised principles of the rule of law. So we disputed the central point that my learned friend keeps driving home, or seeking to drive home, difficulty of enforcement in Russia. We have to have everything outside Russia. That was a contested fact, a heavily contested fact in the lead up to the undertakings being given. Paragraph 23.4 of my learned friend's skeleton argument. Safekeeping in England and Wales of shares in N+. Well, there was no safekeeping of the shares in London of any sort.
Have we finished with Mr. Ray?
We have, my lord, thank you. We're going to very briefly turn up to another paragraph in the supplement, another page of the supplemental bundle in very short order. But the last point that my learned friends seek to rely on is 23.5, which is certain submissions made by Mr. Fenwick at the hearing on the 18th of June. My learned friend has not shown you those, and I don't propose to do so, because I absolutely dispute that Mr. Fenwick was in any way expressly acknowledging, accepting, or agreeing with the supposed difficulties of enforcement in Russia. And we can get that from Mr. Fenwick's own skeleton argument, tab 15 bundle of the supplemental bundle. I'm so sorry to be troubling your lordships with this ancient history, but I have to meet the submission that is made. This is tab 15. These are extracts from Mr. Fenwick's skeleton before Mr. Justice Robin Knowles on the 18th of June. And a very brief canter, para 29, the final problem with the claimant's application under section 70, that's of the Arbitration Act, both as to risk of dissipation as to the difficulties contended for by the claimants in relation to enforcement in Russia. It's simply not established. And then paragraph 30 says the same thing. Paragraph 31, as to alleged difficulty of enforcement, the defence will pray and aid various matters which your lordships don't need to trouble yourself with. 32, this gentleman Kulkov that had set out all this evidence about difficulties of enforcement, it was exploded by Mr. Fenwick. Again, whether Kulkov was right or wrong is irrelevant. Para 33, the same. Apparently Mr. Kulkov had said one thing to one person on one day and then says the opposite to whoever to one client on the next day. Not perhaps an unknown feature of expert witnesses occasionally. Para 39.2, page 72. There's no proper basis to doubt the claimant's ability to enforce a costs award against Deripaska in Russia. 39.3. The suggestion that Deripaska is effectively untouchable in Russia belied by the fact that one of his vehicles lost litigation brought by BNP Paribas for whom Clifford Chance acted. So that's contested. 55. page 74, Mr. Ray sets out comprehensively all the very many aspects in which the claimant's application for WFO departed from the norms of application. Paragraph 56.2, again contesting the suggestion that there was any difficulty about enforcement in Russia. And of course, the point, my lord, is not, you're not being invited to come to any conclusions about that question now. The point is solely this, but importantly this, that the suggestion which is advanced by my learned friends that somehow the concerns of Mr. Chanukin were accepted or understood or acknowledged, whatever word he uses, in no sense were they. We disagreed, or those on my side, disagreed root and branch with all the submissions and evidence that was being put forward. A pragmatic approach was being taken. Every proposition was contested and a solution was reached via undertakings because Mr. Chanukin did not want to have a fully fledged argument about the propriety of his freezing order. So where does that leave us, my lord, that relatively quick canter through the evidence? Well, even on its own terms, my learned friend is wrong. There is no common understanding or common acceptance or what have you about concerns articulated by Mr. Chanukin. Everything is contentious between the parties. No benefit can be obtained of any sort from correspondence that is in contentious litigation leading up to the provision of the undertakings, my lord. Now, while I am in my learned friend's skeleton argument, may I briefly just address a number of other submissions that are made and polish those and seek to deal with them, and then I can move on to other matters in the time available to me. My lords have the skeleton argument, I think, in front of them. Can we go to paragraph 3 now? This is a summary, it would appear to be a summary of the claimant's case. The purpose of the WFO was to do X, Y, and Z. The first 5 lines, we've already seen that there's no benefit to be obtained whatsoever from the WFO. It was contentious. It was going to be looked at again, ab initio, by the judge on the 18th of June. Mr. Deripaska gave the undertakings in respect of a defined block of shares, and then the meat of the submission we find over the page. The last 4 lines or 5 lines of that paragraph, the principal risk against which the WFO and subsequently undertakings were understood and intended to guard. So the proposition is somehow the undertakings were just a sort of continuous flow from the WFO. They did exactly the same work as the WFO. Were understood and intended. Now that must mean understood by both parties and intended by both parties to guard against the risk that Mr. Deripaska would seek to move his assets to Russia, where enforcement would at least be more difficult and uncertain. Well, that's one of the fundamental keystones of my learned friend's submissions. This is right at the beginning of his skeleton argument. This is where it's at. Just totally wrong. They weren't understood or intended to guard against anything of the sort. They're intended to be a pragmatic solution to a situation where a WFO either would or would not be reimposed on whatever terms. And of course, one didn't know that until one had the judgment from Mr. Justice Robin Knowles. And of course, it's understood and well known that parties sometimes seek to compromise their positions in order to avoid a contest on both sides. So that's just wrong, with the greatest respect, paragraph 3. I want to go to paragraph, just to polish off a few points. Paragraph 5, if I may now. Again, we are right at the heart of the case, apparently. The substance of the claimant's case was, and is, that the effect of the vote in favour of redomiciliation was to render practically worthless the shares forming the subject matter of the undertakings, and thereby bring about the very risk that the undertakings were intended to prevent, namely the migration of assets to Russia. Now, there is contained within there a number of, just wholesale with the greatest respect, misconceptions. A, that's not the substance of the claimant's case, because the substance of their case is actually contained in the application notice. B, even if one assumes that is the substance of the claimant's case, for argument's sake, it is founded on two false propositions. One, I don't understand how it can conceivably be said that the vote in favour of the royal redomiciliation, even putting aside my determinativeness point, just let's forget about that for the time being, was to render practically worthless the shares. Now, what does practically worthless mean? Well, we can find that at footnote 1. The shares may have had some notional value. They were of no value to the claimants. I just simply can't comprehend how that submission can be made. The judge himself, at paragraph 67 of his judgment, finds that the shares had the same value and indeed probably had a greater value post-redomiciliation. That is not in any shape or form contested by way of on this appeal. Paragraph 67 isn't contested, so the judge has found on the evidence available to him that the shares retain their value, indeed increase their value. We know that because otherwise they'd have, we saw that the graph, Mr. McGregor's graph, showing that the increase in value.
And I think, am I right in remembering that they are still tradable on the London Stock Exchange?
Well, there are certain GDRs that are tradable on the London Stock Exchange, yes. And they're in a different category though. But it is a publicly traded company. So a value can be established by those GDRs, which I think it's fair to say informs the value of the shares generally.
But are the shares that were the subject of the undertaking converted by redomiciliation into GDRs?
I don't know the answer to that, my lord, I'm afraid.
Well, we do know the answer because it's in the evidence,
And
and the answer's no.
let's look at footnote 1. Whilst replacement shares, well, we know they're not replacement shares now. That's consent. That's common ground. In N plus, what may have held some notional value. No, the judge below, without any dispute, has found they had the same value, indeed a greater value. Then they were of no value to the claimants, insofar as the claimants would ultimately be unable to enforce their ultimate sale to transfer in order to satisfy the will. There's simply, well, I'm sorry to harp on about this. A, there's not one shred of evidence to support that proposition. And B, on its face, it's just wrong. I'm going to get to, I'm moving to a wider point, but let me deal with it here at footnote 1. At the end of the day, the primary promise that Mr. Chanukin had was a promise by B Finance, in the event of certain things not happening after 42 days, i.e. non-payment, to sell shares and remit the proceeds of the shares to RPC for remission to the claimants. That obligation remained as enforceable and as valid and as workable post-redomiciliation as it ever was pre. So I just don't understand what that means. They were of no value to the claimants. They still had a promise by B Finance, a BVI company, which had expressly submitted itself to the English jurisdiction, and therefore the promise remained as equally enforceable post-redomiciliation as it ever was before. I just don't understand footnote 1. If we go back to paragraph 5 where we find the footnote, thereby bringing about the very risk that the undertakings were intended to prevent, namely the migration of assets to Russia, so as to put them beyond the reach of the English courts. Well, it's impossible to discern that supposed risk from the undertakings that were given. It says nothing at all about migration of assets to Russia. And in any event, how does the redomiciliation of the company from Jersey to Russia put things beyond the reach of the English courts? The shares never were within the reach of the English courts. What was within the reach of the English courts was a promise given to the English court by a BVI company which had submitted to the English jurisdiction. A promise equally enforceable before and after. And my learned friend obviously detected the error, the difficulty in that submission, because he then started telling your lordships, we got a difficulty there because it might be more difficult to perfect a transfer of the shares in the Russian registry as opposed to the Jersey registry. And who knows whether a buyer would bought the shares or not because they are Russian shares rather than Jersey shares. There's not one shred of evidence to substantiate that point. My learned friend is simply just creating submissions out of thin air. Nothing in the application notice, nothing in the evidence. The point wasn't even made below that point. But now we're told that the gravamen of the undertaking is to prevent Russian shares being not perfected in a Russian registry. I know nothing about that. 4.5 years have gone by, and that point occurs to Mr. Chanukin on day 1 of an appeal. That's paragraph 5. And one can possibly discern the weakness or otherwise, or strength of this appeal by considering the keystone submissions that are made in support of it. Paragraph 3 and 5. Very briefly, can we turn to paragraph 25 now?
I think what's being said, as I understand it, is that so long as the shares were Jersey shares and the certificates were held by Reynolds Porter, in the event that Mr. Deripaska didn't pay the full amount of the award, it would have been possible for the shares to be sold, and Reynolds Porter would have released the share certificates to whoever.
Yes.
And I think that's what's being said.
There is not one shred of evidence that the ability of B Finance to sell shares and,
Well, I follow that.
and reveal and obtain value for those shares in order to then pass the proceeds to RPC for remission to Clifford Chance was in any way affected, obstructed or prevented by that event. And it doesn't find any articulation in the evidence. I'm sorry, I keep making the same point.
B Finance would have been obliged in that event to sell the appropriate number of shares.
To raise the 95 million
raise
or
the 95
107 million or
million
whatever it might be.
And I might say that implicit in the judge's finding that the shares had the same value is a recognition that there are no particular difficulties in selling, because if there had been difficulties in selling due to difficulties in registration in Russia, that presumably would have affected the value of the shares.
Well, and it would have had to be the subject of evidence from the claimant if they wanted to start asserting that. And I should say that Ms. Barrard in cross-examination expressly conceded in answer to Mr. Pillow's questions that the shares post-redomiciliation hadn't lost value, had retained their value. That was an express concession by Ms. Barrard, being the only witness we were able to cross-examine because of the way Mr. Chanukin decided to formulate his evidence. My lords, if I can move on, because I'm just conscious of the time, paragraph 25 of the, this is a brief point, but one I wish to ensure does not find its way into your lordship's mind, so to speak, collective minds. It is said at paragraph 25, page 11, in response to the imposition of US sanctions on Mr. Deripaska and others, the Russian state implemented a raft of measures designed to protect the assets of those affected by establishing a mechanism for immune, and then one reads on immune from outside interference. There's not one shred of evidence to support that proposition. Not one. Para 26, please, very briefly. For present purposes, it bears emphasis that the effect of an intention behind any redomiciliation to such administrative zones is to ensure that orders made by non-Russian courts are not enforced against Russian companies or their assets. Not one shred of evidence to substantiate that. It's just a submission that is made now without it being the subject of an articulation of the application notice or any evidence at all. In fact, the evidence is flatly against that the intention behind the redomiciliation was to somehow insulate N+ from meddling by third parties. We know why the continuance occurred. Mr. Deripaska has given uncontentious and unchallenged evidence on why it occurred. It's got nothing to do with trying to kind of keep away the paws of European courts or American courts. So I just wanted to scotch that if I'm able to. Finally, paragraph 46. I think I may have dealt with this in another context, but just briefly, paragraph 46, while I'm in the skeleton argument.
Yeah. Yes.
We've looked at the first sentence. We've seen the proposition that these questions are irrelevant, even though they're at the heart of the application notice and have to be proven in order to carry home the contempts. What mattered, and then picking up at line 5, what mattered for the purpose of the undertakings and hence for the purpose of any alleged breach was not the notional rights which the holder of any shares had in an N+ company, quite wrong, but the claimant's ability to enforce the sale of the certificated shares through the mechanism of the undertakings. My lords, there was no question of the claimants enforcing the sale of the shares themselves. The only mechanism was they had a promise by a BVI company which had submitted to the English jurisdiction to do certain things. That ability to go to court and get an injunction against B Finance to indeed sell the shares remained entirely unhindered and unaffected by the redomiciliation. The promise remained intact in every conceivable way.
Well, I mean, the reality is, leave aside the RPC undertaking and how
Yeah,
that's
that's not the subject of contempt.
Whether the shares were in Jersey or a Jersey company or a Russian company, the undertaking given by B Finance, if they'd failed to comply with it, could have been enforced.
Absolutely, and no one suggests that
by the claimants, and as could the undertaking in paragraph, which paragraph it was now, paragraph 4B, of Mr. Deripaska's undertaking.
And Mr. McGregor accepted that
necessary to ensure that B Finance complied with its obligations.
And Mr. McGregor, in his witness statement before Mr. Justice Tier in early July 2019, para 75, I read it to your lordships before the short adjournment, conceded that expressly. Nothing has changed. My promise, B Finance promise, Deripaska's promise remain entirely intact, as against their promise to ensure the sale of the shares. I wanted to now deal in the context of I want to do two more things, or three more things. I'm going to stop at 3:37, which is, I think, when my learned friend sat down yesterday to give us a strict parity of time of 1 hour each, one day each, if that's convenient, of course, to the court. What I wanted to do now, having dealt with the question of context, having dealt with certain submissions made by my learned friend in his skeleton argument, I wanted to go back to the application notice and, fortified or not, as the case may be, by those submissions, look back at the actual allegations that are made and just mop up some further respondent's notice points. Now, if we go back to page 95 of tab 9 of the appeal of the core bundle, as I said to your lordships before the short adjournment, there are 4 things that need to be proven for breach. One is cancellation, 2 is determinativeness, 3 is procuration, and 4, dealing with this as briefly as I can, that it amounted to a dealing or a disposal. Now, my learned Mr. Judge Pelling, in his judgment, dealing with breach 1, right at the end of his judgment, accepted, and I think my learned friend accepted the general principle that to vote is not to deal. And there's a famous dictum, I think, of Lord Justice Carr in Plessy, which we cite in our skeleton argument of first instance, which is in your lordship's bundle, which said those well-known words: to vote is not to deal. And so we say that we take this point by respondent's notice. It's a short point, I should say, that we've already seen that the 4 things they had to prove to carry home breach 1. And when I say 4 things, cancellation of the shares carries with it the obligation to prove that it was that the Russian company was a new entity and that the old company had been dissolved, as I've shown your lordships already. So that might be 5 things, but one of them's carried with the other. The fourth thing was to prove that it was a dealing or a disposal. We respectfully suggest that to vote, the vote, whatever else may or may not be found against my client, to vote, even if he did procure the vote, which I dispute, to vote as a shareholder in favour of a proposal does not constitute a dealing or a disposal. To vote is not to deal. And therefore, my learned friends can't carry home that contempt, even putting aside all the multiple problems that lie in their way before you lead up to that last point. You don't transact anything by voting. You simply signal your agreement to a proposition or proposal. The shares remained exactly as they were on the 21st of December as they were on the 20th of December. My lords, that's all I wanted to say on breach 1. On breach 2, there are a variety of other matters that had to be proven, or different matters that had to be proven to carry that home. 1, procuration, dealt with that. 2, determinativeness, dealt with that. 3, whether or not anything that was done or not done had the effect of preventing, impeding or obstructing the fulfilment of the undertaking given by B Finance. Well, let's pause there. I've already made the submission. Literally nothing that was done impeded or obstructed B Finance's ability to fulfill its undertaking. It still owned the shares, it still had the same value, they had greater value in fact. It could sell those shares. There's no, my learned friend's new point about, oh, there might be a difficulty registering the shares in the Russian registry is a new point. I think I first heard it yesterday, I may be wrong, but it's certainly not in the evidence or the application notice. We can put that out of account in my respectful submission. So that's not proven, that it had any effect at all. And then finally, the further submission or point that is made at the end of paragraph of breach 2 or count 2, that the cancellation, which we dispute, meant that the shares referred to in the undertaking, and then this, would no longer be available for sale, pausing there, would no longer be available for sale. Why? Why would they no longer be available for sale? I just don't understand why. B Finance still owns the shares, they still have the same value, they can still be sold.
But it's all predicated on cancellation, meaning that the shares cease to exist.
Exactly.
They were extinguished.
Exactly, your lordship's right. And/or, I'll take this as quickly as I can, and/or would not be capable of realising any value capable of meeting the outstanding balance. Again, putting aside the cancellation point, there was no evidence at all that they were diminished in value. Quite the reverse. They got a fillip as a result of all the steps that.
Well, that's paragraph 67.
Your lordship has that already.
Judge's judgment, which isn't challenged. As you
No, it's
say.
not challenged. It's not challenged. So that's paragraph, and some of those points I've taken by way of respondent's notice, but I don't want to trouble the court by keeping going back and forth. The respondent's notice is very clear, I hope, in the points we're making. Some of them are shorter than others. Many of these points the learned judge dealt with or didn't. Some of them he didn't deal with. He just didn't need to deal with them on the analysis that he brought to bear. An analysis, I should say, I entirely, with the greatest respect, uphold and endorse. I haven't had time or taken the view it was necessary to take your lordship back through the judgment because your lordship has obviously read it with great care. My lords, then go to count 3. There are various things that need to be proven here. Failed to take all steps as are necessary to ensure that the underlying assets remained available for direct enforcement. So they have to prove to the criminal standard that something was not done which should have been done and which was necessary to ensure a particular eventuality, which is that they remained available for direct enforcement. Well, we've made submissions on the question of what does direct enforcement mean. My Lord Judge Pelling said quite a lot about that, which we entirely, with respect, agree with. The direct enforcement, I think my learned friend made some submissions on the question of direct enforcement yesterday, and let me just address those now. He said, this is page 64 of the transcript, what direct enforcement means in that context is that the undertaking is being given to keep assets available for direct enforcement in the sense of being amenable to enforcement through the mechanisms contemplated in the undertakings, that is enforcement in jurisdictions England, Jersey, BVI, not Russia. Not Russia is the point. That's page 64 of the transcript. Now, I still don't quite understand. I mean, maybe I quite accept it might be my error. What that means. The only promise that was enforceable or not enforceable was a personal promise by B Finance to sell shares in a particular eventuality, which never in the event occurred. But that was the promise, and that was what was enforceable or not enforceable. There was no charge or pledge or lien over the shares. The shares themselves were not available. So the language that is used in the undertaking needs to be moulded to the actual legal reality which existed at the relevant time.
Well, I suppose it could, if for whatever reason, a situation had arisen where where the shares had gone, leave cancellation out for the moment, shares had gone to some jurisdiction where B Finance could not get hold of them to sell them, then there would be a breach of that undertaking because they were incapable of the assets were no longer available for
If there was some sort of
direct involvement
severance
by B
between
Finance
owner and
selling
thing
them.
owned.
That may be what it means. I mean, it's a rather odd.
Yeah.
It's rather odd phrasing, isn't it? Because
Yeah,
as you rightly say, it was never contemplated that that the claimants would have a right. It wasn't a security interest, and it wasn't contemplated that they would have a right to actually obtain the shares themselves, as opposed to being paid out of sale proceeds.
Quite. The obligation to sell was always on B Finance because the share ownership would always remain with B Finance. There was no shift of the ownership. There was just a personal promise fortified by Mr. Deripaska's additional promise which was given on top, a paragraph 4.
On the other hand, if the cancellation means the shares no longer exist, there's no difficulty at all. It's very straightforward what the allegation is.
If the shares ceased to exist, then that is a different question, a different matter. I quite accept that.
I mean, the point I was essentially making is that these difficulties, as you say, potentially arise if cancellation means what Mr. Crowe says it does, but not if it means what you say it does.
Yes, well, but the word cancellation on my learned friend's formulation is just not cancellation at all. It's an entirely different beast, which is we would respectfully say, which is the change of certain characteristics of the shares. But even on that basis, even assuming Mr. Crowe is right, that well, it doesn't mean he doesn't now say, as far as I can see, that the shares ceased to exist, so that the thing on which the undertakings bit just simply evaporated, so the undertaking just became a piece of worthless paper. And that's not, of course, what Ms. Barrard said in her fourth affidavit at paragraph 60, where she expressly said the undertakings extend to the shares post-redomiciliation. I know that she may have tried to resile from that, but that was her sworn evidence when she gave it in 2019, and it was correct evidence, and it was agreed with by Mr. McGregor. But on any analysis, my lord, the phrase available for direct enforcement must mean, we say, because there's no question of the claimants getting their hands on the shares themselves, must mean the promise given by B Finance. B Finance still owned shares post the redom, and their promise to sell those shares remained as enforceable and as alive and as meaningful before and after the continuance. So on any analysis, I would say, with respect, my lord, that the third breach is not made out. For that reason, now just looking at the last lines of that, by failing to procure B Finance to vote against the proposal, we've dealt with that. To move the domicile of the shareholders meeting, the cancellation of the shares caused by the affirmative vote, as procured and/or permitted by Mr. Deripaska, meant that the shares referred to in the undertaking will no longer remain available for direct enforcement. Well, I think I probably made my submissions on that. And in any event, how can it be necessary to not vote in favour in circumstances where the evidence is clear that not voting in favour would have led to the destruction of the company or its nationalisation? My lord, I want to. You'll be pleased to know that my learned friend Mr. Wright, in accordance with the guidance that's been given by this court recently is going to follow on the question of costs. But I'm going to spend 5 more minutes before he stands up. Just, if I may, just addressing certain of the submissions made by my learned friend yesterday. He made various submissions on the meaning of the word cancellation. I've said that that's the key concept that underlies each of the counts. I've made that point. The word, I think it was one of my lords said yesterday that, of course, the application notice needs to be readily comprehensible to the respondent. Not only does the undertaking need to be comprehensible to be enforced to the respondent, for reasons I've got into, so that he or she knows what she's obliged to do or not obliged to do. But when she comes to be committed, she needs to know precisely what she's being charged with. And when you see the word cancellation in this application notice, it has the meaning, necessarily has the meaning, which the ordinary reader, reasonably advised, would ascribe to it. And the ordinary reader, reading those words, especially knowing what had been said by Mr. McGregor, as cross-referred to, would think, not just think, would conclude conclusively, if I can use the double word, tautologiously, that what was being said against Mr. Deripaska was that as a result of things that he had or had not done, allegedly, the shares, the subject of the undertaking, had disappeared. So the undertaking was now a dead letter. And if he decided, well, perhaps Ms. Barrard can gloss that even more, he would look at Ms. Barrard, and of course, as we've seen, he would be confirmed in his understanding because Ms. Barrard adopts it with gusto and vigour. What he wouldn't read, or she would not read, in looking at that application notice, is the special particular meaning that is now ascribed to it through the elaborate and eloquent submissions made by my learned friend in order to carry home his new definition or meaning of cancelled. My learned friend has to engage in hours of elaborate and eloquent submission to try to convert the word cancellation and give it some entirely new meaning, and a meaning that I've never encountered in the English language hitherto in my own reading experience. What he says is, effectively, what my learned friend's submission amounts to effectively is that if the shares, the subject of the undertaking, lost characteristic A or lost characteristic B, then that amounts to cancellation. Well, that's just a misuse of language, but in any event, it's not a case that finds any form of articulation in the attendance, in the application notice or the affidavit, and is a wholly new case which one has to meet. And one shouldn't have to meet wholly new cases. One should be able to know what the case is. I'm just looking finally at some notes of my learned friend's submission to see if there's anything else I need to say. He makes play, that's the wrong phrase, he refers to the fact that the shares cease to be certificated and makes the submission, which I think I've already addressed your lordship on, that well, those shares are more, confidence may evaporate in those shares because who knows whether you could register them at the Russian registry. I've made the submission, this is a submission I think I heard for the first time yesterday. I may be wrong on that, but I think I have. And has no articulation in either the notice or the evidence.
Well, there's no evidence, is there, that it's more difficult to sell the shares as in a dematerialised form than if
No,
the
not at
shares
all.
were combined with share certificates.
None at all.
That must be the point, really.
Ms. Barrard says nothing about that. The application notice says nothing about this. My lords, I think I'm going to in order to give my learned friend Mr. Wright a fair crack of the whip, unless I can assist you further, those are my submissions in response to this appeal.
Thank you very much, Mr. Wright. Sorry. Yes, Mr. Wright.
Thank you, Lord. Well, Lord, I heard your discussion yesterday afternoon with my learned friend, and so we'll try and keep my submissions very focused and very short in light of
Yes.
time. Well, Lord, there's no debate on the law. Both my learned friend and I agree that relevant tests are set out in Excelsior, so I don't need to dwell on that.
No.
One very brief point made by my learned friend orally was that the judge failed to take into account the relevant matter, namely paragraph 140 of the Court of Appeal's previous judgment, which was described as being exculpatory of Ms. Barrad's affidavit. But two very brief points. The first, it's not in my learned friend's grounds or skeletons that the judge failed to take into account relevant matters. The appeal is put squarely on the judge being wrong in the appellate sense, which he equates, I say rightly, as being perverse. But I think it can be dealt with very quickly. It may have been dealt with in full yesterday in any event. And it's that paragraph 140 of the Court of Appeal is not exculpatory in any sense.
No.
It justifies the inclusion of background material, including prior findings, but not the way it was done. And that's at the centre of the judge's judgment on indemnity costs. It's the way in which material was presented. And I say that's a complete answer, and so won't spend any more time on it. But intend to address your lordships in the remainder of my submissions on 2.1, whether the judge was wrong in the appellate sense as a matter of principle, and 2, very briefly on the practical matters that your lordships discussed with my learned friend yesterday. Address the point of principle in 3 ways. First, and it's so obvious it doesn't need much explanation, but the judge, of course, had a very wide discretion when it comes to costs. And that makes it that much harder for my learned friend to show that in exercising that discretion, the judge was wrong in the appellate sense of being perverse. And I think my learned friend acknowledged in his submissions that such appeals are rare, I would say very rare in practice. The second point, which goes to the heart of the judge's decision, is, as they were described yesterday, the adjectives in Ms. Barrad's affidavit. And the discussion yesterday was premised on whether the adjectives went too far. And of course I say they do, but I say the argument runs slightly wider than that. And the additional point is, why are the adjectives there at all? And what we say is, of course, affidavit evidence and witness evidence is not the place to argue the case. And part and parcel of that, prohibition on arguing the case through evidence, is it should not contain, because there's no need or place for them, adjectives, flamboyant language, and rhetoric, which is the hallmark of submission or argument, and not evidence. Your lordships looked at the relevant sections yesterday, so I won't dwell on them in any detail, but it may assist to have open paragraph 25 of Ms. Barrad's affidavit, that's paragraph 35, page 173. And I say these points are relevant to the whole affidavit we made reference to paragraph 25. This paragraph encapsulates first the adjectives, the rhetoric going too far, and I do say it goes too far. The use of the phrase, for example, systemic dishonesty, is inflammatory language. It doesn't appear...
I'm sorry, Mr. Wright, which paragraph?
So paragraph 25, which is...
Oh, yes,
page
thank
172.
you.
This is the description of Ms. Justice Pear's findings.
Systemic dishonesty and egregious...
Yes.
separately.
And my lord, those are exactly the 2 points I was going to pick up as being inflammatory language. And they don't appear to be justified on the basis of the passages Mr. Justice Pear quoted in that paragraph. But the second point, I say, regardless if one accepts the accuracy of those descriptions or not, they are not evidence. It is Ms. Barrad arguing the case, and doing so by giving her subjective opinion or interpretation of findings that the judge has made, and making arguments as to what the court should do with those findings. It formed no part of the case that had to be made out by the claimants to show that these matters, that the background material involved flagrant or egregious breaches. It would have been perfectly sufficient by way of evidence to say breach. And so the language is not only inflammatory, it is unnecessary, and as I say, it is not evidence. And this is the approach that was taken throughout Ms. Barrad's affidavit, not simply reporting on the evidence, narrating the findings, but interpreting them and giving her own subjective opinions on them. And in the judge's word, that hinders rather than helps the forensic process. And just before I leave this point, I note that my learned friend in his skeleton refers to Practice Direction 57AC. This is paragraph 54 of my learned friend's skeleton, and notes that it wasn't in force at the time, not applicable to this affidavit. Now, the judge doesn't seem to have relied on Practice Direction at all, so one might see it as a slightly defensive point to be made. But two things do in my submission come out of it. The first is that the mischief the Practice Direction was aimed at was precisely this. And you can see that, my lords, through the declaration that's required to be included in trial witness statements now. And I'll just read it, but it's in, of course, the Practice Direction itself. The witness has to say, I understand it is not my function to argue the case, either generally or on particular points, or to take the court through the documents in the case. And of course, this was nothing new. This, of course, had always been the case, that you shouldn't include such material in evidence. But it was one of those rules that was honoured in the breach far too often. And so the declaration has sought to, and this is the words used when promoting the Practice Direction, to promote and enforce best practice on the preparation of witness statements. And Lord, for the reasons I've said, Ms. Barrard has obviously not complied with that. She has argued the case, and she's done so through rhetoric, adjectives, and submission. The second point of relevance on the Practice Direction comes from paragraph 5, and that is that one of the sanctions available for breach of the Practice Direction is an adverse cost order. And once again, I say this just confirms what was always the case, which is that one of the appropriate sanctions for breaking the rules of evidence is an adverse cost order. And in the case of a paying party, an adverse cost order, as in this circumstance, means an order for indemnity costs. So what we have is an affidavit which argues the case, and I say that's without doubt, and goes too far in doing so. And it simply cannot be said that it's perverse to award indemnity costs of an occasion by responding to that affidavit in those circumstances.
Well, what costs do you get under the judge's cost order on an indemnity basis? What are the costs of responding to Ms. Berard? Are they all the costs of defending the whole application?
Well, that takes me on to the practicalities, which I was going on to go. I'll go straight there because it's obviously relevant. Well, I confess it never occurred to me that that order meant all the costs of the application, and the words the judges used at paragraph 17.
What does it mean, though? That's the difficulty.
Well, I have two submissions on that, or two possibilities on that. I say it applies to both of these. The first is, undoubtedly, Mr. Deripaska and his legal advisors would have had to spend time reading and considering Ms. Barrard's affidavit. And I say that falls squarely within the wording the judge used, which was the cost of an occasion in responding to the 8th witness statement, as he described it to Ms. Barrard. And I say that is undoubtedly within the confines of that decision. The second is that, of course, responsive evidence was put in, directly responsive to Ms. Barrard's affidavit. I think that forms 5 affidavits, at least extracts of which are all in the bundle. And as I say, that, again, falls within the description of costs of an occasion in responding to the 8th witness statement. At the absolute most, that requires you to read in to what the judge said, the words responding in evidence, rather than simply responding. But I say that's consistent with what the judge found, and it's in particular consistent with the distinction the judge drew between evidence and submission. Although he found that the language had gone too far in both affidavit and skeleton, the only one which merited sanction was in the evidence. And so, my lord, I say it would be entirely logical if the sanction was only went so far as to apply to the evidence in response. So, my lord, on the practicalities, I say that's what the judge's order means, the judge's decision means. In context, would certainly not be a large sum of money in the context of these rather sprawling and hugely expensive proceedings. The amount to which this would apply would be relatively small, and that's commensurate again with what appears to be the judge's intention, that only an element of the costs would be subject to the indemnity principle. I have one final point on the practicality in answer to my
So
board.
just looking at what the judge says in
Yes.
his cost judgment.
Yes.
Paragraph 15, he rejects Mr. Grant's submission that all the costs should be assessed on the indemnity basis.
Yes.
And when he says in paragraph 17, it should be focused exclusively on the costs of and occasioned by responding to the affidavit of Miss Berard. You say, do you, that that does not mean responding to the application notice, which would include everything.
Yes.
It's responding specifically to what Miss Berard said, Mrs. Berard says in the 8th affidavit. Is that how you understand it?
Exactly so, my lord, yes. Final point, I think, on the practicalities, and it's in answer to my Lord Justice Nails's question. This never progressed. No steps were taken towards detailed assessment. There was a very specific reason that, in order to do so, required an amendment to the licence under which Mr. Deripaska solicitors and counsel have to act. And before that process was completed, permission to appeal had been granted, and so it would have been wasteful to pursue it any further. So,
Sorry, to which question was that an answer?
well, I think you asked whether any steps had actually been taken to recover any costs and
Yeah,
what had been done in terms of what was sought, essentially. But
Yeah.
we can't gain anything from that because the process never
So
started.
it hasn't gone to assessment, in other
No.
words.
I did have some other questions which I asked Mr. Crowe, which is first, do you have any sense of what this point is worth? That's to say the difference between standard and indemnity costs, assuming that the order means what you say it means. And second, if paragraph 25 had not been there and words like flagrant had not been used, you would still, on your side, have had to read the affidavit and respond to it. And I suspect that the evidence you would have put in would have been more or less identical to what you did in fact put in. Do you want to say anything about that?
I do, Lord. In answer to the first, I don't have a sense, my Lord. I'm also in a less advantageous position, even though my learned friend, I wasn't trial counsel. Although I've seen the affidavits, I wasn't involved at all in their preparation. But what I would say is, even on the wider of the two instances I gave of what should be covered by this, we're talking about the cost of preparing 5 affidavits. That is necessarily limited. I don't want to say it's going to be small, but it would be limited. And in the context of these proceedings as a whole, I say it would be a small proportion. So we're not talking about a large sum of money, whichever way one looks at it. As to the second, my lord, I say, first, it's not necessarily the case that the inflammatory language doesn't add to the cost. I don't accept that's necessarily true. Inflammatory language, as I think the judge put it, adds more heat than light. It can raise the temperature, and that can cause an increase in cost. But even if that is taken, that is not a reason why an order for indemnity costs is perverse. In Excelsior, the Lord Chief Justice said the circumstances in which indemnity costs may be appropriate. I think the phrase he used was of infinite variety. It's not a requirement that costs be increased by the conduct which leads to indemnity cost order being made. It's simply a requirement that there is some reason for it. And here I say it is. And I say that is actually very much reinforced by the fact that the practice direction 57 AC now confirms that an appropriate sanction for breaching it is an adverse cost order, even though that doesn't necessarily mean the costs have been increased. So, what do I say? There's no necessary connection between the costs being increased and indemnity costs.
Thank you.
Yeah.
Unless I can assist your lordship.
Thank you very much, Mr. Wright. That's very helpful. Thank you. Yes.
Lords, I hope you'll excuse me if I'm a little staccato in our closing reply, because there's quite a lot to cover. I just want to tick off the points in the order in which they were made, if that's convenient. My learned friend started with some contextual matters, which he said led to a submission that the continuance of the committal proceedings was disproportionate. The first element that one might look at is the delay which he dwelt on. He said it's November 2019 when the application was issued, and here we are in March 2024. It is, of course, regrettable that the case has taken this long, but that is a result partly of my learned friend's clients' unsuccessful application to get the proceedings struck out, and partly a result of a succession of adjournment applications by my learned friend, which are listed. I'm not going to take you through them, but the chronology is in the core bundle, tab 4, page 42, 4 or 5 adjournment applications. If we are right and the judge below reached the wrong conclusion, it would be, in our submission, a regrettable position if, having run down the clock by taking a number of bad points, my learned friend's client has generated a position in which there is so much delay that the court throws up its hands and says, enough is enough. If there's been a serious breach that needs to be found, and the fact that unsuccessful applications by my learned friend's client have resulted in the delays, should not deflect this court from deciding the points that are up for appeal. Second point, my learned friend emphasised that my clients were paid out more than 4 years ago. We would simply observe 2 things. The first is that the Court of Appeal was well aware of that on the last occasion. It said so explicitly at paragraph 27 of its judgment, and that did not deflect it from concluding that there was at least an arguable case that the contempt proceedings were not disproportionate, which it said in paragraph 104.4 and 105. And the only thing that has changed since the Court of Appeal said that is that we have had the trial which the Court of Appeal expressly contemplated. And if that trial has reached the wrong conclusion, then the fact that my clients were paid out some considerable time ago in our submission is neither here nor there to the proportionality of what has gone on. It is also worth reminding you that the judge below in this case made an explicit finding to the criminal standard that the only reason Mr. Deripaska paid us out was that Mr. Justice Tier made orders for sale of his assets, a further freezing order, and a requirement to pay the full amount of the award into court in July 2019. That was actually the trigger for the payment. Third point my learned friend sought to make was he said that the redomiciliation benefited my clients. It's not immediately clear what the relevance of that argument was, where it fits into the structure of his submissions, but presumably it was intended to touch on either whether there was a breach or if so, whether it was a serious breach. We just wanted to make a few points in response. The first is that this was exactly a point that was run previously in front of the Court of Appeal and dismissed. Paragraph 90, little 1b, dealt with this and dealt with it on the basis that it represented a misunderstanding of the purpose of the undertakings that were offered. The purpose, the whole point of the undertakings was to ensure that assets remained available for enforcement proceedings that did not require a resort to proceedings in Russia, and moving the entirety of EN Plus to Russia defeated that purpose. So it's been decided by the Court of Appeal before. It would be, in our submission, anomalous and wrong for this court on exactly the same material to reach a different conclusion. The Court of Appeal also said, paragraph 82, little 6, that if the flip side, the corollary to this argument about supposed benefit to my clients is that it was potentially damaging to EN plus for the redomiciliation not to go ahead, what the Court of Appeal said in paragraph 82.6 is that the fact that it may be burdensome or inconvenient to comply with a court order or undertaking is not an excuse if there has been a breach. And if there is a problem, what should happen is that the party who is bound should apply to the court, which is what Mr. Deripaska and his then solicitor, Mr. McGregor, both admitted should have happened in this case. The second point, just in relation to the supposed benefit, well, so just to park that, the point is, in a sense, it's not just that the Court of Appeal has decided this already. The Court of Appeal just decided it rightly, because the purpose of the undertakings is to preserve the availability of assets without resort to proceedings by way of enforcement that require the engagement with any engagement with Russian courts, and that is what was destroyed by the redomiciliation. Second point, though, what would have happened to EN plus but for the redomiciliation is a matter of speculation. My learned friend repeatedly said that several of his client's witnesses had given evidence on which we didn't cross-examine them, that they thought that EN plus could have been nationalised or that it could have gone into liquidation, but that was all prognosis. It was hypothetical prognosis. In deciding whether Mr. Deripaska has committed a breach of the undertaking, it is not the function of the court to speculate as to what might have happened if he hadn't acted as he did. The question is what he did a breach of the undertakings properly interpreted? And the third point is just a matter of logic under this heading. As a matter of logic, we submit that Mr. Deripaska could only say that the redomiciliation benefited my clients if, in the event, what had happened was that B Finance ended up having to sell shares in EN Plus Russia, as it had become, and if it was the preserved value of EN Plus Russia that enables my client to be paid. And there is a flirtation with that assertion in my learned friend's skeleton. He says in paragraph 30 of his skeleton that the completion of the Barker plan provided Mr. Deripaska with the liquidity to pay my clients. You will note when you go back to that paragraph, there is no footnote to any evidence, and the reason is there is no evidence at all as to where the $105 million that was used to pay my clients actually came from. There is no evidence that it resulted from the sale of shares or the realisation of an asset that was somehow preserved by the redomiciliation. So there is just no evidential basis for the assertion that the redomiciliation benefited my clients, and it simply presupposes my learned friend is correct on the interpretation of the undertakings, because if we are right on the interpretation of the undertakings, the redomiciliation took away the very thing that they were that the undertakings were intended to preserve. The fourth point is my learned friend dwelt a certain amount on the supposed extent of Mr. Chernukin's knowledge of the redomiciliation. The first thing is simply to point out that before the undertakings were given, what was demonstrated is that Mr. Chernukin had seen some press reporting that a redomiciliation was under consideration. So what does Mr. Chernukin actually know at that point? And what does he not know? He doesn't know if the press articles are entirely accurate. He doesn't know whether there is going to be a redomiciliation pursued.
There's no evidence as to what Mr. Chernukin did or didn't know. He hasn't given evidence.
No. He hasn't.
He may not have thought that the redomiciliation was going to take place. On the other hand, he may have thought that it definitely was. We just don't know.
No, we don't. So my learned friend cannot make any assertions about what Mr. Chernukin knew.
Well, he's entitled to say that Mr. Chernukin had the press reports and read them.
Exactly. No more. But in full flight, my learned friend also asserted that Miss Berard knew all about it, in his words. One must got to be a little bit careful about knew all about what? Knew all about, as at the date when the undertakings were offered, my client had seen press reporting about the possibility of a redomiciliation. That did not mean that he knew a redomiciliation was going to be pursued. It did not mean that he knew that a redomiciliation would succeed, that it would tick all the boxes that needed to be ticked. It did not mean that he would assume that Mr. Deripaska would do anything to support it. And it did not mean that he would assume that Mr. Deripaska would not come back to court if, on a proper reading of the undertakings, Mr. Deripaska had to do something in pursuit of the redomiciliation, which would involve a breach of the undertakings. And so in our submission, simply the evidential basis for trying to get some kind of traction in relation to this point just doesn't exist. We would submit that the state of knowledge of my client is irrelevant to the interpretation of the undertakings. It's wholly unclear in what respect the learned friend was suggesting, and I'm not sure he was indeed, after some question from the court, suggesting that there was any relevance on interpretation. In our submission, the question whether my client did or didn't know about the redomiciliation doesn't help the court in deciding whether there was a breach, because the question of whether there is a breach is what do the undertakings mean and what did Mr. Deripaska do? And the question of my client's knowledge of any redomiciliation is not relevant to the gravity of any breach, if there was a breach, because that is a question of what Mr. Deripaska knew. So in our submission, this whole line that has been pursued in relation to my client's supposed knowledge is irrelevant. The only footnote point I would just make is this, that in the course of an exchange about that with my learned friend, the court said that it would be surprising if RPC knew about the redomiciliation in June 2018. That was why I asked my learned friend to carry on reading in paragraph 75 of McGregor 2, where you may remember he said, as far as I was aware, redomiciliation was not under consideration at that point. So if, in fact, Mr. Deripaska knew in June 2018, when he was offering the undertakings, that the redomiciliation was likely, it would appear he hadn't told his English solicitors. The final contextual point that my learned friend urged on you was to say that the court could only make a finding of a technical as opposed to a serious breach. I just wanted to explore both the law and the evidence in relation to that a little bit. It is perfectly right to say there is obviously a difference between a serious breach and a technical breach. A serious breach might, for example, involve an abject failure to give any disclosure, if disclosure has been ordered by the court, pertinent to a freezing order, for example. A technical breach might, for example, involve giving disclosure in correspondence when the court orders you to give disclosure in a witness statement. The same evidence gets across, but it gets across in the wrong form. That might well be a technical breach. My learned friend was, took you to Sector Guard and said you don't need to look at the facts. Well, it does actually help to look at the facts, because the point of Sector Guard was that the court had ordered disclosure of a list of clients that were supposed to have been contacted or not, on the assumption that that list as a document existed, and the requirement was that it had to be disclosed. It turned out the list didn't exist. So there was a technical breach, but it was an order that it was impossible to comply with from the outset. So those are examples of a technical breach. What my learned friend did, and what in our submission is not justified as a matter of legal analysis, is to suggest that a serious breach means exactly the same thing as a knowing breach. In our submission, that isn't supported by the authorities. There's no description in Sector Guard by Mr. Justice Briggs, as he then was, of what he means by serious as opposed to technical. The illustration of the facts of that case gives you some clue about what he was talking about. And I don't propose to go to them, but we would just, one of the authorities in the bundle is the case of Ignite in the authorities bundle, which is in tab 15. And I don't propose to go to it, but if you look just, it's a very short passage at paragraph 61 in Ignite, page 518. It regards seriousness as in a sense, a compound test involving a number of aspects, which no doubt will depend on the facts of any given case. And yes, awareness of the breach may be one of them, but the gravity of the breach will be another. And so in our submission, it is not right for my learned friend to assert that if the court can't make a finding of a knowing breach, then by definition it is only finding a technical breach, because you can have a serious breach without it being a knowing breach. So just as a matter of the sort of the legal framework within which
Mr. Justice Sweeting, in that short passage there, talks about a previous decision in Crystal Muse and Metric, that the factors may include whether the breach of the order was deliberate or unintentional. That's clearly knowing.
Yeah.
Whether its seriousness was appreciated, I'm not sure whether that's any difference really, and whether any reasonable excuse was put forward. And
Yeah.
that's,
so it's a combination of factors. There isn't just an exact equivalence
there
between
isn't,
knowing
there isn't, but
and
I mean,
seriousness.
obviously that
It's
one's in
plainly
the same
relevant.
sort of territory.
I'm not suggesting for a moment knowing of a breach is not going to be a relevant factor, but it is not. The two should not be equated with each other.
Crystal Muse is in fact a sentencing decision.
Exactly right.
Yes. Yes.
Exactly right.
Mr. Justice Lawrence Collins, I think.
And the other point, leaving the law to one side, on the application of the law, even on its own terms, my learned friend's submission that this court is only able to make a finding of a technical breach, that submission assumes he has satisfied you that it is not open to us to invite the court to make a finding that Mr. Deripaska's breach was contumacious. So I just wanted, I anticipated a little bit of this in our opening, but my learned friend made a number of extremely bold assertions about what did and didn't happen at the trial. The full extent of the cross-examination of Mr. Deripaska is not in the Court of Appeal bundles. But essentially, the framework of the submissions that we made then and we make now are these, that it is the legal principle as to whether or not a litigant can invite the court to make a finding. The overriding principle is fairness. That's what the relevant paragraph in Griffith and Toohey said. And one of the aspects of fairness is whether or not a party has had a reasonable opportunity to answer the case against them, and if one is asking a court to disbelieve somebody, one needs to cross-examine them. Does one need to go through a particular formula and say, I put it to you, you did know that the breach was deliberate? No, we would submit that that sort of formulaic approach cannot be right. What we did, and what has been included in the appeal bundle, is our closing submissions, which identified 6 points. And the closing submissions are to be found in, sorry, I've lost the page reference, I'll give it to you in a moment. In our closing submissions, it's in the supplemental bundle, tab 48, and it's really pages 7 to 16 of the transcript, page 343 of the bundle. And what we did was we identified, I think, seven factors from which we were inviting the court to infer that Mr. Deripaska's evidence that he didn't think that the redomiciliation involved a breach was untrue evidence. One of the points my learned friend didn't mention. One of the points, it's quite a long passage, and I wouldn't invite lordships to read it now, because it might detract from your attention to my oral submissions. But one of the evidential points upon which Mr. Deripaska sought to rely, and this touches on also on the question of procurement or procuration, is, you may remember in Mr. Deripaska's witness affidavit, he said he had become comfortable with the idea of the Barker plan and the continuance by May. Now, we cross-examined him about that because the Russian legislation providing for continuance in these special administrative regions wasn't enacted until July. And so I put to him in cross-examination, you said May because you knew that was a date before the undertakings were given to make it look as if you didn't do anything after the undertakings had been given by way of procuring a breach. Now, whether or not the judge believes the answer to that, the fact is that kind of line was put in cross-examination to give the lie to the assertions he was making, and the other, just again by way of illustration, I'm not going to go through the whole lot of the cross-examination, the other illustration is the timing of the May 2019 RPC letter, which was the first notification by the other side to my clients about the redomiciliation. And again, I cross-examined Mr. Deripaska about that on the basis that he only instructed RPC to write after the Jersey Financial Services Commission had given their approval about a fortnight earlier. And that was again because he knew perfectly well, we put in cross-examination and we submitted in closing to the judge that the judge should infer that the timing of that letter indicated that Mr. Deripaska knew perfectly well that the redomiciliation involved a breach of the undertakings, and if Mr. Chernukin had been given notice any earlier that that was the effect of the redomiciliation, he would have been back in court like a shot, seeking replacement security, which is exactly what Mr. Chernukin did immediately after getting the May 2019 letter. So for my learned friend to say boldly that we didn't cross-examine Mr. Deripaska with a view to inviting the court to reach the conclusion that he knew perfectly well that the undertakings had been broken by the redomiciliation is simply not true. As I say, I won't take you through.
I'm sorry, Mr. Craig.
Yeah.
It may just be me, but I'm not sure I'm following that.
Okay.
The Reynolds Porter letter
Yeah.
was the 29th of May
Yes.
of 2018. So that's
2019.
2019.
Yeah. So it's after the redomiciliation has gone.
So the response that came to that letter in 2019 was from your client was what? This.
The response was, well, if the immediate response, because the 29th of May letter said, you will agree that we can withdraw the undertakings, won't you? To which Clifford Chance said, no, we won't. And if that's the result of the redom, we need replacement security, which is why we ended up back in front of Mr. Justice Tier on the 3rd of July, and he ordered a payment into court because he accepted that the redomiciliation meant that we didn't have the protection that we previously did.
No, quite.
The timing of, as I say, the May 2019 letter, and the other matters that we made submissions to the court about in cross-examination in our submission provides a perfectly good evidential basis from which to invite the court to infer that Mr. Deripaska was not giving truthful evidence when he said that he didn't realise that the redom would result in a breach. Whether we succeed in that or not, that's fine. But my learned friend is trying to raise a bar to us even asking the court to make a finding on that.
You're not asking this court?
No, indeed we're not. We're just saying that if we can satisfy you that there has been a breach, the question whether it is a deliberate breach, a knowing breach, having not been decided, that is just going to have to be remitted. Exactly how that is handled would be a difficult matter.
That's why I asked you the question. I wasn't following what the specific context was. I now understand.
Yeah, I'm sorry. Right. So those were some of the opening remarks my learned friend made. He moved on to deal next, I think, with procuring. And so far as that is concerned, having cross-examined Mr. Deripaska as we did in relation to matters such as the timing of the enactment of the Russian legislation in July, we would invite the court to reach a conclusion that, to draw the inference that his evidence that he didn't issue a direct instruction was wrong. We didn't have evidence from Mr. Wisniewski. All we had is Mr. Deripaska saying, I didn't tell Mr. Wisniewski how to vote, and because of the credibility of Mr. Deripaska on other matters, and because of the importance of the redomiciliation, we invited the court to draw the inference that there was an express direction. Mr. Deripaska would not have left something as important as the survival of EN+, which I think we got him to agree in cross-examination represented about 80% of his personal wealth. He would not have left something like that to chance or the risk of any misunderstanding, and he would have likely issued a direct instruction. The second, I've already identified to you in opening, the evidential material upon which we relied. Mr. McGregor, in his second witness statement, para 55, said Mr. Deripaska did, via B Finance, vote in favour of the redom, so there was evidence of that. So there was one line of evidence is Mr. Deripaska absolutely did procure the vote by active steps taken by him. The other line of argument is that Mr. Deripaska had authorised Mr. Valiev to take the necessary steps to see through the redomiciliation. That is Mr. Valiev's uncontested evidence, because it was helpful to us. So Mr. Valiev, in paragraph 31 of his witness statement, says that he told Mr. Wisniewski how to vote, and Mr. Deripaska, in paragraphs 37.1 and 37.2 of his fifth affidavit, said that Mr. Valiev had Mr. Deripaska's authority to give that recommendation to Mr. Wisniewski. So a step is taken immediately before the vote in December 2018, clearly 6 months after the undertakings were given. A step is taken by a duly authorised agent, which in law is a step taken by Mr. Deripaska.
The undertaking also says whether directly or
Exactly.
indirectly.
Exactly so. We've included, I don't ask to go to it, but we included, I think, reference in our skeleton to the Worldwide Fund for Nature and THQ Jack specific, which teases out what doing a relevant act indirectly by servants and agents means. That's authorities bundle, tab 3, page 22 at paragraph 18. I don't ask to go to it now. The position we take is that there was evidence before the court to find and a finding of procuring by direct action by Mr. Deripaska could have been inferred properly, and if nothing else, by his own evidence and the evidence of Mr. Valiev. Mr. Valiev did an act immediately before the vote on the authority of Mr. Deripaska, and that is sufficient. The next point I wanted to deal with.
It's not a ground of appeal, is it? That the judge failed to make a finding of procuration.
It is not a ground of appeal. We are left in the position of the paragraph 17 of the judgment, saying that he he felt he didn't need to decide because either it was procured or could have been stopped. Cancellation is the next issue my learned friend addressed that I wanted to answer. And the first point I just wanted to deal with is my learned friend's attempt to attribute to us an approach we are not advocating. He said that our approach was to say that you look at the undertakings, you look at the evidence, and you see if a breach was established. That is not the way we have presented the case to the court, and I hope you recognise that what we suggested and what we continue to suggest is that you look at and interpret the undertakings, and then, as I think I said more than once yesterday, you see whether the actions that are alleged in the committal application and proved constitute a breach. My learned friend spent a certain amount of time emphasising that our skeleton for this appeal focused on the errors in the first instance judgment, which is not entirely surprising because it is our purpose to satisfy you that the first instance judgment was wrong. But that does not mean that we are doing anything other than inviting this court to look at the undertakings so that you understand them, and then to look at the allegations made in the committal application to see to what extent they have been proved. There was also a thread before we actually get on to the actual substance of whether or not shares were cancelled within the meaning of the committal application. There was an attempt to suggest that there has been some change in the focus or the direction of our argument from trial to here. That, in our submission, is not a fair criticism. I don't ask you to go to it, but now that our trial skeleton is in front of the court, it is apparent from paragraphs 69 and 70, which is in the supplemental bundle, tab 57, page 455. Don't ask you to look at it now, but the thrust of 69 and 70, paragraphs 69 and 70 in our trial skeleton makes it perfectly clear that the case that we have been running is that the meaning of the undertakings is that that the subject matter of the undertakings is certificated shares in a Jersey registered company, and that the allegation that the shares were cancelled is a reference to the fact that certificated shares in a Jersey registered company unquestionably ceased to exist as a result of the redomiciliation. And that is, in our submission, exactly what we said in trial, and it's exactly what we are saying in this court in paragraph, for example, 46 of our skeleton argument. And it is entirely based on the allegations in the committal application as to what Mr. Deripaska did and whether that involved a breach of the undertakings. So the questions that the court is then faced with in terms of what the committal application is alleging is what does cancelled mean in that context? And we submit that the key point there is paragraph 22C of the committal application, page 95, which says in terms that the shares in EM Plus secured pursuant to the undertakings and defined therein as the shares, capital S, would be automatically cancelled. And in our submission, in circumstances where it is the case that the effect of redomiciliation is that certificated shares in a Jersey registered company no longer exist, the only fair description of that is that those shares are cancelled. It doesn't mean that there are not shares in existence under the law of a different jurisdiction, nor does it mean that the Russian EN Plus company is necessarily a different legal entity. That's not part of the alleged breach. We're not making, as I said in opening, abstract allegations about the company law consequences of, or how you describe as a matter of company law, the translation of Jersey shares into Russian shares. We are making the allegation in paragraph 22C in relation to the undertaking shares. And that is the context in which cancellation is used there. The second point is, as we submitted, even if you are not satisfied that any shares were cancelled, is what has been alleged and proved sufficient to prove a contempt. And my learned friend, with the greatest respect, doesn't have an answer to that. If properly analysed, what has been alleged in the committal application and proved constitutes a contempt, a breach of the undertaking. The fact that we have not also proved that any shares were cancelled cannot result in a breach not having been committed. The consequences, the interpretation of the undertakings is absolutely central to your finding on that. And the same is true the next word that my learned friend dealt with is determinative. My learned friend read out a dictionary definition. The word determinative doesn't have a single fixed legal meaning in all contexts. The context in which it appeared here was that it was being used to mean and refer to the but-for test.
Where does it say that in the application notice?
Yeah.
Where does it say that?
Oh, sorry.
Where does it say that what it means is but for?
It doesn't say that on the face of the application notice.
Does it?
No. What has been drawn to my attention there, and I apologise this didn't get into the bundle, is that in Ms. Berard's 10th witness statement, precisely that clarification was given before trial. We can make available the relevant
There's a
paragraph.
limit to how much additional material
No.
the court's prepared to allow in.
I understand that, and I'm sorry that this point didn't occur to us earlier. But if one is dealing with an assertion that there was some lack of clarity as to what a particular word meant in a particular context, and there is a documentary record that demonstrates what the answer to that is, in our submission it would be regrettable if that didn't go forward. The question then...
You were showing a whole load of, I forget whose statement it was, one of the Russian witnesses, about 15 things that had to happen.
Yeah.
Before the continuance was take place. Let's
Yes.
just let's pick one that's obvious, the Jersey Financial Services Commission.
Yes.
If they had simply said, well, in our discretion, we're not prepared to permit this continuance at all.
Yeah.
Even if there'd been a vote, Mr. Deripaska had procured it, do you still say there was a contempt? I mean, that's just... you might have been doing things that were preparatory to committing a breach of the undertaking, but he wouldn't have actually broken it.
His action would still have been the actus reus of a contempt. It would not have produced any damage if the redomiciliation had not gone ahead, and therefore it wouldn't...
That's right, Mr. Crowe. What is covered by the undertakings are acts which have a certain effect.
Yes.
If they don't have the effect, because, for instance, the Jersey Commission refused consent, then there is no breach. There cannot be a breach. There's no effect.
My lord, the effect of the vote is to facilitate the redomiciliation. Other events might have happened which prevented that from going ahead, but that does not alter the fact that the procuring the vote, or the fact of the vote, is a necessary precondition
Yes,
to the...
but I think in answer to my Lord the Chancellor, when you said it would have been a breach, even if the Jersey Commission had refused consent, that can't be right.
Paragraph 4A of Mr. Deripaska's undertakings. I shall not take any step which has the effect of preventing, impeding, etc., the fulfilment of the undertaking set out in
Yes.
the B Finance letter. Well, on this hypothesis, they wouldn't have had whatever step
Well,
it
it
took,
wouldn't have had
wouldn't
the
have had any such effect at all.
Well, it wouldn't have had the immediate results, but it would, at least arguably, have the effect of impeding in the sense that it would. Sorry, if the redomiciliation does not go ahead, then there isn't an effect.
No.
No, I accept. Yes, I do accept that. Yes,
really.
yes, yes.
Anyway, it's not your strongest point.
No. So the other point in relation to determinative is the same as the one we made in relation to cancellation, which is that irrespective of whether the act that Mr. Deripaska did was determinative of the redomiciliation, irrespective of whether that has or hasn't been proved, if what has been proved, alleged and proved, in the application notice is sufficient of itself to constitute a breach, then in our submission it is incoherent for the court to reach a conclusion that there hasn't been a breach, because we haven't also proved something else that is alleged in there. My learned friend spent a certain amount of time pouring some scorn on some passages in an earlier skeleton we had put in dealing with an analogy with causation in contract. That whole line of argument was actually responsive to Mr. Deripaska's attempt to do exactly that. So I don't think you're assisted by that. The next point is not Russia. My learned friend said somehow that the not Russia was a new argument and that it wasn't present in the evidence supporting the committal application. With the greatest respect, that is not true. It was the risk of a retreat to Russia was the whole basis on which the worldwide freezing order was sought and obtained. And I took you to Ms. Berard's first witness statement, supplemental bundle, tab 3, page 13. And it explains whether Mr. Justice Robin Knowles can be regarded as having made any definitive decision on the point. It explains why paragraph 7C of the worldwide freezing order excluded assets in Russia. That's supplemental bundle tab 4, page 22. So it was the evidential basis on which the freezer was sought. Secondly, it was the evidential basis on which the July 2019 application for the payment into court was made to Mr. Justice Tier, and that is Berard 4, paragraphs 61 to 64, supplemental bundle 29, tab 29, page 137. It was, thirdly, it was the basis upon which the committal application was made, Berard 8, paragraphs 28 and 30. And the assertion was also made that there was a dispute as to the context. And I wanted to pick that up here because my learned friend urged on your lordships that his clients disputed our allegations of a risk of dissipation and our allegations of a risk of non-enforcement in Russia. We wanted to say two things about that. First is it simply misses the point of the argument that we were advancing. The point of the argument which I was making yesterday, which I hope your lordships gathered, was I was not suggesting that Mr. Deripaska agreed that he was going to move his assets to Russia in order to hide them, or that he agreed he had such political influence in Russia that he would be immune to enforcement there. What we were saying is that my clients had those concerns, and it was those concerns that prompted them to apply to the court, and it was those concerns that sculpted the nature of the undertakings that were offered and accepted. And that is precisely the point that the Court of Appeal accepted and held, and this is in our submission a finding, in paragraph 99 of its judgment, which is supplemental bundle, tab 44, page 285. where they say they set out one of the judge's conclusions and say, as set out above, this is to miss the point. Sorry, this is to miss the essential purpose and effect of the undertakings. The undertakings were all about securing assets for the appellants that were outside Russia and available for ready enforcement of the award. My learned friend is seeking this Court of Appeal to reach a different view. And in our submission, that is just not an appropriate way forward. The court, on exactly the same materials, said what it said in paragraph 99, and my learned friend is now trying to persuade you to reach a different conclusion. And in our submission, as I say, that is not an invitation you should accept. And the final point, just under this heading, is that it is perfectly apparent from what Mr. Fenwick said, then representing Mr. Deripaska, that he did know. My learned friend asserted that we were making some fallacious point, suggesting that the undertakings were offered on the basis of an understanding of our concerns. I do want very briefly to take you to two of the passages in what Mr. Fenwick said. I know this is unusual, but it does put paid to a point that my learned friend was urging on you quite vigorously. And so in the supplemental bundle at tab 16, page 78, letter B, Mr. Fenwick said something inaudible. And then thirdly, the suggestion that the sanctions make it easy or likely that Mr. Deripaska will retreat to Russia with his assets is unsustainable in circumstances where the bulk of his assets are those held in relation to the, it says JV, it's common ground, I think, that it meant to say the Jersey shares in EN+. What was being offered by Mr. Deripaska's team was an assertion of an absence of a risk of assets moving to Russia. This may also be relevant, a significant part of why it is relevant that Mr. McGregor seems not to have known about the proposal, the possibility of a redomiciliation. Mr. McGregor then instructing Mr. Fenwick. And the other very short passage is in the same bundle at tab 50, at page 364, third line, page 364, third line, again just after some inaudible words. So what is being offered here is very good rights. Now, my lord, there has not been identified, and accept that we have refined these in order to give the greatest comfort. We have tried to meet every concern that your lordship has shown and Mr. Crowe has shown. It was avowedly the case that the undertakings were being presented to the court in order to meet the concerns that my client had expressed regarding the risk of dissipation, the risk of the retreat to Russia, and the difficulties of enforcement to Russia. To suggest that that is not relevant contextual material in our submission is incorrect. Contextual material, just to remind you, I don't ask you to go to it, but we took you to paragraph 44 of the Rangers, SDI and Rangers, judgment, which is in the authorities bundle at page 424. The interpretation of an order may be critically affected by knowing what the court considered to be the issue which its order was supposed to resolve. So if the affidavit, the witness statement evidence, the submissions of counsel, and so on do that, if they provide material from which it is safe to infer, to understand what the issue which the court's order was intended to resolve, then in our submission it is relevant and admissible material that should be taken into account. Again, second point under the relevance and admissibility of contextual material, it is what the Court of Appeal in this case did on the last occasion, paragraph 99. Again, my learned friend is asking this constitution to take a different approach on exactly the same material. And in our submission, that is precisely the kind of process that leads to the delay in the final disposal of these proceedings. Correspondence, witness statements, whatever, are relevant if they disclose facts which are known to the parties, and my client's concerns were a fact. Whether they were well-founded or not is a different matter. The other point in relation to context is simply to remind you that although obviously we do seek to derive considerable assistance from the contextual matters, your lordships do not need to go through the correspondence or the witness statements to understand the importance of not having assets disappearing off to Russia, because that was the basis and indeed the content of the worldwide freezing order, and each of the undertakings refers to the worldwide freezing order. The undertakings were being offered to replace that, and so the context in which they need to be interpreted is by reference to a freezing order which had been granted. Whether it's contested or not is neither here nor there. It had been granted. There was clearly a risk to Mr. Deripaska that it would be continued, and it had been granted on the basis of a perceived risk of a retreat to Russia. So you don't need the context in order to, you don't need the correspondence in order to understand the context. And as a separate point, you do not need any context to interpret the very clear words of the undertaking, which describe 45.5 million certificated shares in a Jersey company. The language of the undertakings in our submission is perfectly clear. My learned friend said several times it's descriptive language. Indeed it is. It describes the subject matter of the undertaking. And he asserted that there was some significance in the fact that Mr. Deripaska's undertaking doesn't refer to the RPC undertaking. He is only very formally correct on that, because the true position is that the Deripaska undertaking refers to the B Finance undertaking, and the B Finance undertaking expressly refers to the RPC undertaking. There is simply no doubt that the three undertakings must be construed together consistently to make sense. Their subject matter must be the same. And there is no point in the RPC undertaking, which is no doubt why my learned friend wanted to draw your attention to it not being referred to in the Deripaska undertaking. There is no point in the RPC undertaking unless the words certificated shares in a Jersey company matter. So in our submission, it is perfectly clear that read together, the undertakings capture those shares, and the advice that we submit that the redomiciliation crystallised was in producing a result in which those shares simply ceased to exist. Could I just take one moment? I'm conscious I'm fractionally over time. Could I just take one moment to take instructions if there are any other points that my clients would wish me to urge on you? I'm just reminded that there were exchanges again in the Court of Appeal on the last occasion. So it's my learned friend sought to gain comfort from his assertion that the shares continued to exist. I'm not sure if I heard the capital letter in the way he described that. If we are talking about the shares capital S as defined, they didn't continue to exist. Shares, as I said in opening, are a shows in action. They're not a chattel that somehow changes its character but continues to exist. Shares only exist as a bundle of rights under a legal system. Shares in Jersey EN plus cease to exist. A shareholder may have, as we saw, and you saw from the notice of the EGM describing what happened, shareholders may get migration shares which have equivalent economic rights. But they hold the shares under a Russian legal system. It is, with the greatest respect, legally nonsensical to say that the shares continue to exist. They can't. And that was the point that Lord Justice Snowden put, and it's page 253. I think I took you to it in opening, but it's page 253. I won't go to it now.
You did take it.
I'm grateful. So in those circumstances, we do submit that the subject matter of the undertakings undoubtedly disappeared. It was undoubtedly an act which Mr. Deripaska procured, and what we have alleged and proved is sufficient to satisfy the test for establishing a breach. I'm grateful I have overrun slightly, but I'm grateful for your indulgence.
My lords, might I just make one responsive point, which is not to make a submission, but my learned friend has put into the further documents certain passages from his cross-examination of Mr. Deripaska, which I apprehend he's put in to try and make good the Toohey and Griffiths points. I would invite the court, I know it's in position, but it's only 8 pages. I would invite the court to read them. If he's seeking to rely on those cross-examination pages to make good the point that he fulfilled his obligations under Toohey and Griffiths, if he wished to make the point that my client was telling a lie or giving false evidence about certain things.
He
needs to read those. Your Lordships, I'm so sorry.
He referred us to a passage in his closing, which he said we shouldn't read now, but should read later.
Yeah. Well, the closing of it's closing is one thing. You've got to actually put
No,
the
I
case.
understand the point.
But I just invite the court just to look at those pages, because it is my submission. I'm not going to repeat the submission. They come nowhere close to fulfilling the Toohey and Griffith obligations. That's all I wanted to say.
While my learned friend's been speaking, I've just realised there's one other point I just wanted to correct. He said several times that it was a new point ventilated for the first time yesterday, that there would be some difficulty in completing a sale of shares once the share register was... I'm grateful. We made it, Ms. Berard made it, Lord Justice Snowden made it, and I made it to the Court of Appeal by way of submission. It's not remaining new, it's about 3 years old.
Thank you very much.
I don't know Ms. Berard.
I think we probably ought to draw a line, despite the forensic ping pong. We're very grateful for the extremely skillful way in which this appeal has been presented on both sides. Obviously, we will reserve our judgments. We will let you have a draft as soon as we can. No promises as to when. When you receive the draft, please limit yourselves to any typographical errors. It's not an opportunity for re-arguing matters. And please also could you pay close attention to the terms of the embargo at the top of the draft judgment and ensure that that's complied with. But once again, thank you all very much. Could I just ask one thing? This courtroom is needed for a judicial seminar in about, well, it's actually at 5:45, but certainly they'll need to start setting up at about 5:30. So if your teams from your chambers and solicitors firms could at least make sure that the bundles have gone, that would be extremely helpful.
Thank you.
Absolutely. Thank you
very much.
Will rise if able.